Thank you, Chairman Tillis, Ranking Member Schiff. It's great to be having this same hearing. 2 years later, we had an identical hearing 2 years ago. And despite the strong bipartisan agreement about the importance of protecting American intellectual property from Chinese theft and infringement, I wish we had seen more progress through the Senate and the House. Foreign websites continue to steal and profit from American copyrighted content. China remains the world leader in the theft of American IP, using what it's stolen to directly infringe the rights of American companies and put American consumers at risk. And our patent system still needs serious reform, or we're going to find ourselves looking up at China as the new global innovation leader. I do, at the opening, though, want to say something about recent developments at the Library of Congress. President Trump fired the Senate-confirmed librarian, someone I've long admired, and then tried to fire the Register of Copyrights, who was appointed by and answers to the librarian, not the president, and who plays a critical role in copyright standards and protections, increasingly urgent in the age of AI, where the question of whether or not copyright will be upheld is at issue. And as the name suggests, it is the Library of Congress, not the Library of the White House. Register Perlmutter is a longtime public servant with deep experience at the PTO and the Copyright Office, and testified before this very subcommittee in November and has been leading that office into the 21st century. I'm encouraged by statements on both sides pushing back on these unlawful moves, but I think it's important that we push back on efforts to intrude on the legislative branch prerogatives. Professor Cohen, if I could, I think, of course, I think that we need to strengthen our IP system to better compete. In your testimony, you highlight the need to enact 3 bipartisan bills: Prevail, Para, Restore. Why is restoring injunctive relief critical to maintaining our global IP leadership, and what's the consequences if we don't?
Yeah, great question. And again, I can respond with the official statistics of China, recognizing that the statistics are problematic, but they're the only statistics we have. The injunction rate in China for an IP dispute, if you've won, is about 98%. This is basically automatically available. Now, if you're going to go after a manufacturer, let's say of the type that some of the other people testifying today are trying to pursue, you're best off if you could get a judgment in your favor where the product is manufactured and get an injunction against it. And in that respect, China offers a competitive advantage when you consider that, again, according to available data, right, the time to first instance resolution of the case is 6 months, 3 months on appeal. So within 9 months, you've exhausted your appeal, you have a final injunction, low damages, so you have to calculate that into your strategic planning. That, when you look at global patent litigation, for example, where we have these multiple jurisdictional cases appearing before the Unified Patent Court, the Federal Circuit, the Chinese courts, knowing that an injunction is available as an automatic outcome is a significant advantage to helping to determine not only the national rate, the royalty for that patent, but the global rate.
Could you speak to the importance of having an intellectual property enforcement coordinator to bring together different actions that are spread across disparate entities that hasn't been filled in several years across two administrations? I think it's a critical role. How would it help us speak with one unified U.S. voice and ensure that enforcement actions are more effective than they currently are?
Yeah, well, IP enforcement, and we've already heard about some of this today, bridges many disciplines, including consumer safety, including pharmaceutical safety, including obviously patents, trademarks, copyrights, and other areas, and including state and local government. California has a very active criminal docket in intellectual property enforcement. New York does as well. In fact, at one time, New York probably had as many cases as the federal government. Most of them were small scale, people selling goods on the street. But the ability to coordinate them nationally, on a state level, and finally internationally, right, where often the evidence is located overseas, is critical. And that's the reason we need a coordinator.
That's something I hope we'll all be working on a bipartisan basis to press to finally fill this position after a long time. Mr. Mueller, Mr. Bors, I worked for 8 years for a global manufacturing company. We had a whole room at our headquarters of fakes that carried the same trademarks and stamps and materials and had been made all over the world, and yet failed to meet the product safety and performance standards that the company I worked for was built on. Mr. Bors, your talk about Moen faucets was a new example to me of a risk to consumers and to product safety. We've made progress fighting counterfeiting, with the Inform Act, something Senators Durbin and Cassidy led, but we all co-sponsored. But Senator Tillis and I are continuing to work on a bill called Shop Safe that holds online platforms liable for selling counterfeit products unless they adopt certain best practices. What do you think online platforms like Amazon and eBay could be doing better to stop the flow of dangerous counterfeit products from China to the United States?
Thank you very much for the question, Senator Coons. First, I applaud your guys' work on the Inform Act. It's the right steps, and we're making further steps. With regards to your additional act, I think there are absolutely tools within various e-commerce platform sites to help govern better, making sure products that are for sale, both in my industry as well as many others, meet safety standards and meet national code requirements. It's about ensuring that those platforms all have the liability to enforce those, and the manufacturers who are trying to sell on those platforms are telling the truth when they put that information in.
I think millions of Americans unwittingly buy counterfeit products day in and day out and are largely oblivious to the risk. Senator Grassley and I have long co-chaired the Trademark Caucus, and I think there's a lot more we can and should be doing to protect storied American manufacturers, multi-generation manufacturers like yours. Last question, I know I'm over time, with the tolerance and forbearance of the chair and ranking, if I might, Ms. Temple. Finally feels like we're making some real progress here on site blocking after years. One of the key roadblocks to getting a final deal is whether ISPs should bear liability both for should benefit from immunity, both prospectively and retrospectively. Can you help us understand the difference between these types of what kind of immunity ISPs might be looking for and what you think a path forward on that specific deal point might be?
Yes, thank you, Senator. I would say that, in our experience in the countries that have adopted site blocking, immunity has not been an issue. ISPs have not routinely been sued for enforcing site blocking regimes. So, I think in our experience, we don't think that this is a provision that is necessary at all. But certainly, if the ISPs feel more comfortable having at least a narrow, targeted immunity provision that would protect them from any liability for enforcing or implementing a site block, that might be something that would be appropriate. But again, in our experience, that's not been an issue in the 55 countries that have adopted site blocking regimes.
How important is site blocking to your industry?
It is a critical enforcement tool. Obviously, as I mentioned before, there are billions in dollars that are lost annually to digital piracy. And unfortunately, there are safe havens for these foreign operators where we can't actually go after them and get them, like in China and Vietnam and elsewhere. And the only way that we can effectively enforce our rights is by basically cutting off their customers. And that is making sure that they are not able to get these unwitting victims from the United States to buy their, or purchase their services. And so site blocking is a critical tool that we use in all of the countries that we are able to do so.
Well, thank you. Thank you all for your testimony, and to the chair and ranking, thank you so much. I look forward to working with both of you on these bills. Thank you, Senator.